Busunya, the removal of Chief Justice Gertrude Tukono procedures are concerned citizens any other groups fence enye mrakwanso enam sasunti omode application akwakodan the Apex Court of Ireland na ene ana Supreme Court justices etina asemi so eteki the majority decision 4-1 na asemi James Kwabena Bonfe awoda the group ano any Theodore Kofi Atta. These applications were similar because at the end of the day no more fence a prima facie case omampanyini gina so take committee no right procedures na was a faso na putupromu ye de suspend ye maami ewo na dwumadie ho na lawyer Kwabena Kusi enne ono ana chief justice na kasa lawyer enya asem keto akwa na jebre ye court amani boni wo ha wa bra obi tina so wasem pato ne sa friend de asem ni nchemu ankasa
Supreme Court then see wo
so and answer na ye be court no na we only had information about one case. Case Nimonyam for ye friend Theodore Kofi Atta Kwe Edibasum Supreme Court say anka processes are president na shasye enko wieche no ebia current chief justice ya suspended no ebia ebeyi ne fi ni position as chief justice no anka Supreme Court no entwentwen so oma order na yentwentwen processes no so answer. That was the idea ye the bar court and by ebe do court no na yesa say sir there is a case application be a group being so file also trying to achieve the same net result if you like that ultimately no omunyina say court na make it similar determination on the applications now omo file here no so court no shall see the new case a group file case no omudin de
Center for Citizenship,
Center for exactly
Constitutional and Electoral Systems
and Electoral System.
Yes.
And you know, court no omu that particular matter, and the argument of the plaintiff in this particular case, no, so the argument is say in court no and order say the committee now president has set it up no it will be null and void and it will be unconstitutional because President Nimuna Nkasano acquire offer so from the outset or they could set up the committee say every week we are met now say 3 times in a week to hear the matter. Nina no any so bia or emrem into court no emma interlocutory injunction so that almost sitting no and a proceedings no and a inquiry nina no nka court no emfa interlocutory injunction no and toso so that court no yes akra na nobody according to their case no obie ni wa obe suffer any damages because after all there is an acting chief justice even though the substantive chief justice no has been suspended no there is an acting chief justice into no or there's not going to be any injury or minor be suffer if the court takes such a decision. That was the thrust of the argument. And the argument again was that the president has not made available to the suspended chief justice copies of the prima facie determination. This was very contentious in open courts today, that the president has not made copies of the prima facie determination available to the chief justice who has been suspended. the processes in Inano, the court should place the interlocutory injunction on the process, particularly the committee now, or inquiry into the whole matter. Now, the panel is a 5-member panel.
Okay.
That was presided by the acting Chief Justice, His Lordship, Justice Paul Bafuboni. And then we also had Justice Isifu Umoro Tanko Amadu.
Sure.
There was Justice Yuni Kolendi and Justice Henry Anthony Kofi.
Okay.
And then Justice Yao Atare Daku.
Okay.
Now, omutie argument lawyers come out with a majority 4-1 decision. HSA Asemna Yadibeda in court, it was unmeritorious and you dismiss as such. Almost afraid the second case court, and then that was what we had in mind, Senka. That was the one filed by Theodore Kofi Atakwe,
yes,
who among other things, asked the court to place an interlocutory injunction also on the committee constituted by the president to potentially remove the Chief Justice from office. Now, Sir Plaintiff, he also asked the court, to suspend the operationalization of the warrant of suspension President now issue against the Chief Justice under Article 146(10)A of the 1992 Constitution.
Mm-hmm.
Now, it was their case that warrant, before the president can exercise that discretion, I say instrument be APA, I say echo parliament. Now parliament they consider it within some 21 days before the president will or can arrogate those powers to himself, for want of a better word, to issue that particular warrant. In the absence of that instrument, argument they say president, wa fa mrakwan so and or they suspend the Chief Justice, and the court should place again an interlocutory injunction pending the substantive matter itself. And also, court, on a brief recess, they pronounce a 4-1 majority decision. HSA Assembly is unmeritorious, and those applications or that particular application was also dismissed by the 5-member panel.
Okay. Now, and also the same 5-member panel now.
Exactly the same 5-member panel.
Okay.
Theodore case also the organization also case also the Center for Center.
Yes.
I can't really recall
census. You're trying to kind of census. That's the center. Center for Citizenship, Constitutional and Electoral Systems. Omo penny or down no the executive director of that center Dr. James Kwabna Bonfe and the organization.
And yes. Just to chip in this one, so in the argument of Dr. Bonfe lawyer, he made the claim that the president has not given copies of the prima facie determination to the Chief Justice. But that particular case, now Chief Justice, I am suspended or no, and also for a lawyer. Inti the lawyer Kwabna Kusi, or no representing Chief Justice get to talk on, because it is clear that the suspended Chief Justice, on any case, it doesn't align really with the case of the state. Into the Attorney General, in the sense of the suspended Chief Justice, Attorney General cannot represent her.
Yeah, but
even the lawyer ever court.
Yeah, but more so, so we share the writ before the court now. Her ladyship Gertrude Araba Isaba Sakitokono, a party to this case. On a second defendant.
Second defendant.
Yeah, once a party, she should be represented in court, and that's why the lawyer echo,
Attorney General no represent chairman of the committee now, president, are establishing.
Okay.
That is Scott Poorman.
Scott Poorman.
And also representing the Attorney General.
Who the Attorney General?
Okay. So, Dr. Justice Sh0cks and I represent Dr. Dominic Ayine.
Okay.
I'm raising this point because there was a stark contrast between, initially that was how it appeared, between the argument of the lawyer for the organization and lawyer for the suspended Chief Justice. Because, again, the lawyer for the organization made a point that the president has not furnished the suspended Chief Justice with copies of the prima facie determination. Now, lawyer Kwabna Kusi, during Onone argument, he made the case that, in fact, there has not been any prima facie determination as far as his camp is concerned.
As far as the suspended Chief Justice is concerned?
Yes, as far as Ono lawyer is concerned, there has not been any prima facie determination made by the president. So, raised some concerns among the panel because Ono Nick client and Onu Munankasa as lawyer, almost say they entirely support the position of the lawyer representing the plaintiff. Nti support to plaintiff no court. Na plaintiff nankasa ka say president hasn't finished the suspended CJ with the prima facie determination. So you can interpret it to mean that so there's been a prima facie determination. But lawyer Kusinsu in his submission in Ekache court say as far as he is concerned there is no prima facie determination. He had to further explain. In his explanation, Okache court say if there were any prima facie determination, it would have found its way in the content of the communication between the executive secretary to the president and the suspended Chief Justice. Abra or letter or communication, a man say a prima facie case has been made, and he will give reasons for that, for the establishment of the prima facie. But in the absence of reasons, it renders the whole suspension unreasonable and arbitrary. Those were the words I used here. He has to explain, and then eventually he came to align with what the lawyer for the organization had made, that the president had not really furnished the Chief Justice or the suspended Chief Justice with the prima facie determination. The long and short is that at the end of the day, court say the case the Supreme Court is unmeritorious, and and the Dr. Bonfenso organization and the court and the same pattern. It's a 4-1 majority decision. The same person dissented on both, while the 4 others voted in the other direction.
The dissent here, justice made the dissent here on both. Hello, Latif.
Yeah, only me too.
Nami Busa say justice is 5. Now, why in the dissent here, on both?
So the justices. Let me just run you over the justices of the Supreme Court who sat on this particular matter. So we have the acting Chief Justice, Justice Pobafu Boni, who was presiding, Justice Isifumoro Tanku Amadou, Justice Yoni Kolendi, Justice Henry Anthony Kopi, and Justice Yao Asare Dako. Justice Yao Asare Dako, Onuna Odesenti here on both cases ni nyina.
Okay, that's fine. That's fine. I am now Latif. Bibiani ebese ba bidin komo bio. Why?
Yo.
Very well. It is there you have it. And applications mienu before the Apex Court of the Land by 4-1 majority decision. No court na abo mienu ni nyina atwegu. 2 applications no had some similarities. Said the Latif eka no. Omu nyina the net effect and say court na enhwemfa tabuo bi ento amampanyin process no eso. Said the ebeya dwumadi a cost so omo hwehwe suspended chief justice in nsem no anka ebe hold on kakra na omo ahwe aka nsem ni nyina wie ansana omampanyi beto so a wetumi ato so omo argument primarily and say wo hwa say petition call omampanyi ho a when it's about the chief justice it was say omampanyi edema council of state. And now, together with the president, we determine a prima facie. Prima facie say, ye share petitioner ababeto ye nimia. Ye free send the pie fan in this case, ye chief justice no, or one sembi year no, and only prima facie. And on the face of the petition no, we feel say one sembi was so baby year no. Says our determination on opinion the Council of State make here. Constitution is show opinion say on set up committee. Na committee ne enhwehwe nsem se committee ni wie no mo de mo report ebro man pay okay ya hwe nsem ni mo awie ye free say chief justice otena odi na djuma enye ye nti man panyin man ntena nchen ana say man nkofie o man panyin is bound by that was o man panyin de no ye adjuma so mo kasi ya hwe nsem ni mu ye free say was ma me ne to na adjuma so a o man panyin ni eni ho asem bi aka e was so to na adjuma so de James Kwabena Bonfe group yi ena one Theodore omode call court na echire mu a time a omampanyin council of state it determine say former suspended chief justice won seme also baby yi ano no na e was say omode enyina so a omode determine sa de ne kokoma maame no say okay ya hwe nsem nim kakra ye ma wo do response by ya hwe petition abeda yanim ye free say won nsem bia wo say wi ano ba we ni nti and ye free say one same was we ano e was say omampanyin sa de emma suspended chief justice no and omu chim say sa de no omampanyin anye and nam so omde call court say saint sa de nti no otoko so ko form a committee ne kra no say enye mra kwan so and a supreme court ka say there be na omu nkyere ba bia o constitution article 146 a kyerɛ sɛ was omampanyin say omuye prima facie determination ni wi a e wo so omuma chief justice aso ete omo nkyere bibisa eniho and a court na abo nsem no ato ediego nti baby aye wo sisi a eno no ye behwe se yensaka Dr. James Kwabena Bonfe ni group or executive director Emma census na Center for Citizenship, Constitutional and Electoral Systems sa kuoi ene de assembly echo Supreme Court. Indiana James Kwabena Bonfe